Well, tonight we'll turn to the controversy surrounding grand juries, those following decisions out of both Staten Island and Ferguson, Missouri that sparked civil unrest. Now, the top judge in New York calling for change to the grand jury process that would give judges more power over such cases. Our legal panel joins us to weigh in. In the Obama administration, vowing to appeal a Texas judge's move to temporarily block the president's executive actions when it comes to immigration. President, he's being accused of breaking the law. Will the decision win or lose when it comes to appeal? Plus, we will turn the case surrounding the death of American sniper Chris Kyle. The defense making its insanity argument for the alleged shooter, what deems someone insane when it comes to the eyes of the law. Good evening and welcome to RFL. I'm Richard French, and thank you so much for joining us. And tonight we will begin in New York, where a top judge is calling for reforms surrounding the grand jury process. Jonathan Lippman, Chief Judge of the New York Court of Appeals, proposing legislation that would eliminate much of the secrecy surrounding the grand jury process. It would also grant judges more power over grand jury proceedings. Lippman said that the grand jury is a medieval institution, his words, that must be modernized. And on Tuesday, in his State of the Judiciary speech in Albany, Lippman discussed the importance when it comes to transparency.
Equal justice, that defining principle of our country, requires that every human being has access to the courts and a judicial system where the scales of justice are exquisitely balanced. As Chief Judge, it is not my role to defend or decry a particular grand jury decision. But the grand jury is a vital component of our judicial system. Under the law, it is first and foremost a part of the court and an institution for which the judiciary is ultimately responsible.
All right, let us bring in our legal panel right now. Jim Kasuris, criminal defense attorney in Manhattan. He sits on the board of directors of the New York City Criminal Bar Association, frequently lecturing not only at New York Law School, also the bar associations in Queens and New York City, and a visiting professor at the University of Birmingham in England. Doug Von Ois, founding partner of Carson Von Ois, focusing on corporate misconduct, and he was also selected by the Legal 500 as one of the most influential trial lawyers in the country. Mayo Bartlett here, an attorney of the law offices of Mayo Bartlett, PLLC, and a former chief of the Bias Crimes Unit at the Westchester County DA's office. And Mark Furnish joining us, Brooklyn law professor, recognized as a super lawyer, not because of the cape, but of his abilities in the courtroom. He's also argued before the U.S. Supreme Court and recently named Criminal Lawyer of 2014 by the Institute of Jewish Humanities. Gentlemen, thank you all for joining us. And I should say that Judge Lippman, who's a fan of Mayo, no explaining taste here, he wants to be part of this conversation, not tonight, but he'll be joining the panel soon. We're going to break this conversation down to 2 points. One, the broader grand jury process, as he called it, medieval in need of updating, and also how Judge Lippman would like to see police-related shooting cases handled differently. But let's talk on the macro side, and I'll start with you, Jimmy. Do you agree with the justice that it is medieval how the grand jury process works right now, and it's time to peel back the layer of secrecy and have the thing more transparent and out in the public?
I do agree entirely, and I applaud the movement towards more transparency, because the way the system works right now is just simply unfair. There's no reason why we can't, as defense lawyers and the public, get a view into what happens in a grand jury. You can protect witnesses through redactions. You can get protective orders in situations where there is danger. Give a practical example
for our audience. You're representing a client. You're at the grand jury level. They come back and they choose to indict. What would you like to know that you currently don't?
In my trial preparation, it is absurd that I have to wait by statute until the day of trial to get grand jury minutes so that I know what other witnesses said under oath. And I have literally no time to investigate the claims that they make, whether they're true, whether they're not. It is completely unfair, and there's no reason for it in most cases. That's the macro end. With respect to this little part of it where he wants transparency and he wants judges to be involved in just the police cases,
Yeah, I want to get to that.
Okay,
one
we'll
second.
talk about it later.
But Doug, like Jimmy, you used to be a former prosecutor before you went over to the dark side. I kid. But to that point, you knew when you were on the other side here that there's an importance to some of the secrecy of what goes on in the grand jury. Does it outweigh the benefits of making it more transparent?
I think it does. You know, these are people from the community that are dedicating part of their lives to make decisions for the community about whether people should be indicted or not, and they have a right to be, you know, kept secret, kept from the process. As soon as you interject them as people into the process, you're now taking that secrecy and you're peeling it away, and you're making that an element in the grand jury proceeding. I don't think it's
Can you
outweighs
have
it.
your cake and eat it too, Mark, in that can you have enough redactions that you protect the privacies but yet have enough transparency to answer Jimmy's questions?
Well, this isn't going to grant any more transparency as a practical matter. The problem is that it's not a macro level reform. It's a micro level proposal in response to one, in our state, one specific decision. So it doesn't go, as a criminal defense lawyer, as Jimmy said, you always welcome more judicial oversight. But the problem is you have to be troubled by the process of a two-tiered system with special rules applicable only to police on citizen crimes. To me,
But do first the more macro thing before
But
you
he's
get
not
down to the
proposing
police.
the macro
But I'm saying
reforms.
no, on the broader level as it relates to grand juries overall, without even a police shooting involved. Should there be more, should you learn more about what and why the grand jury chose to indict?
well, let's look at what he's proposing. The only way we're going to learn anything more is in the one solitary situation where the grand jury chooses not to indict a police officer who kills or
Okay.
maims a civilian.
Well, let
We're
me-
not going to get that
All
transparency.
right, let me pivot to there, and we get to the police-related shootings. Now, to that level, I've heard district attorneys say, keep it in our hands. I've heard people call for special prosecutors every time. I've heard even the Justice Department saying that maybe they need to get involved. Now, I got judges saying, let us get involved in the process. You've been on all sides of this, Mayo, right? Who's the best people when a police is involved for the shooting for all the reasons we've talked about on this show, why that's a different case than maybe others? Who should be in charge?
I think you need a special prosecutor, and for all of the reasons that have been stated. I mean, to Jimmy's point, number one, you shouldn't be receiving information right before you're ready to select a jury for trial, because you're at an inherent disadvantage. You can't even properly advise your client until you've seen the sworn testimony, which often is very different from what's written in the complaint or in an indictment. All on top of that, yes, D.A. Thompson in Brooklyn came back with an indictment in the Gurley case, but it's a single case, number one. He's one prosecutor out of many in New York State. If you go to a special prosecutor, you have a body that's a standing body with subpoena power, full enforcement power, that has a budget, and that budget can even be taken from the existing DA's offices if they're not going to be handling these cases. What it does is it adds an appearance of independence. And sometimes that appearance is as important as anything else, because right now, if you go to the district attorney's office in Westchester County, you go to the third floor, that's where the grand jury is. And so it's in the DA's office itself. It shouldn't be. It should be independent. It's not a branch of the DA's office. It's a branch of the court. It should be supervised
Isn't
by
that
the
what
judge.
the judge was trying to do?
And this is my problem. First of all, sorry. The proposal usurps the power of the district attorney or whoever should be doing it. The proposal is, forget about transparency for a minute, that in these situations, a judge should basically be the referee in the grand jury who is dictating what questions should be asked, what witnesses should be called. The only way to make that determination is to have everything in front of you in order to discern what's right and what's wrong. We need a special prosecutor. It's not about who's called and who's not called and what witnesses are asked. It's about the inherent conflict in these cases of having the district attorney that works with these police officers, putting the case in and dictating what the result is. We need a special prosecutor. It's like having a referee at a game where there's only one side playing and it's rigged. It's not going to do anything.
You know the DA in Brooklyn's going to say, hey, Jim, what are you talking about? I just secured an indictment here. The system can work. I'll only talk about it as the only non-attorney at the table. It just seems that if a DA wants to get an indictment, and you can argue this both ways. Sometimes, if you're the cop in Brooklyn, you can say, Officer Liang, wait a minute, this guy wanted to get an indictment before the whole thing started. And if you don't want to get an indictment, you can say, I'll throw it in there and whatever comes out, comes out. Is that the best way to do this?
Well, you know, we always say bad facts make bad law. So now you're going to tinker with the process that's been pretty good for a long time. And you're looking at these cases and you're saying something went wrong. You know, you really have to look at when a DA indicts, what they indict for, and when there's a trial, do they get the top count? Do they get a conviction on the top count, or do they get a lesser? And if they get a lesser, it could mean that the trial went bad, but it also could mean that they were indicting just to appease the public, and that's wrong.
I mean, it's so easy to get an indictment right now. What they want to do is make it even easier. It's the rarest bird indeed where a no true bill is returned. It happens once in a blue moon, and it happens in a highly celebrated police case in Staten Island. So the answer is to make it even easier to get an indictment? I mean, the famous phrase about being able to indict a ham sandwich, what are we going to be able to indict now? Just the empty piece of bread?
Well, but only certain ham sandwiches get indicted. So you can make sure that other ham sandwiches don't get indicted. And it shouldn't be an issue of whether the DA is seeking an indictment. The DA should be there to present, or whoever's presenting this information should be there to present the facts, present the information, and the grand jury should be given enough information so that they're not going to be scapegoated later. They're given an opportunity to make a
that's
determination.
exactly what the DA claimed he did.
Well, right, but see, what we don't know is what charges were presented, if any. We don't know anything about that. The grand jury can be basically political cover for a prosecutor's office. Toward Doug's point also with respect to the secrecy. All of these people who are testifying in the grand jury ultimately are going to testify at trial if the case goes to trial. Right. So it's not as if you just come in, testify in the grand jury, and walk away never to be heard from again. So you're going to be scrutinized. You're going to be cross-examined where you're not in the grand jury. So if you're a witness in a case, either you're coming forward for the big show, which is going to be the trial, or you're not. But and again, Jimmy hit it right on the head. You can have protective orders. If you have a child of a tender years, a young kid, somebody who's a rape victim, teenager, something like that, you can shield that person and have their testimony can even be taken by video these days. So they don't even have to actually be in the courtroom. You can be confronted without the person actually being there.
Would a special prosecutor have put witnesses in that he knew were going to commit perjury in the Ferguson case? Absolutely not. An independent prosecutor who has no connection to a situation, to the police, to the accused, who doesn't have that agenda.
But that's not what Lippman's proposing.
And that's
He's
why
just
I disagree.
proposing greater judicial oversight, and there is in the state system already ample judicial oversight after the fact. In the state court, everybody at the table knows this, the judge inspects the grand jury minutes as a matter of routine course. So the only way this proposal is going to have any practical effect is if there's no indictment.
Although, Mark, you know also that in each case that proceeds to trial, there's been inspection and review of the grand jury minutes, and a judge, in order for that case to reach trial, has found that the grand jury was presented with proper information.
Guys, I just want to play the clip from Judge Lippman. Again, he did his state of the state, if you will, here as related to the legal system or as to where we stand in New York. This is what he had to say specifically about these police cases.
Of immediate concern are the perceptions of some that prosecutors' offices, which work so closely with the police as they must and they should, are unable to objectively present to the grand jury cases arising out of police-civilian encounters. First, I am submitting legislation that will require that grand jury proceedings in cases involving allegations of homicide or felony assault arising out of police-civilian encounters be presided over by a judge. I am proposing that a judge be physically present in the grand jury room to preside over the matter. The judge would be present to provide legal rulings, ask questions of witnesses, decide along with grand jurors whether additional witnesses should be called to testify, preclude inadmissible evidence or improper questions, and provide final legal instructions before the grand jury deliberates.
First of all, I never knew a judge could enter legislation, so I learned something today. But secondly, I saw you not nodding along at agreement.
Well, the presentation of a case to the grand jury and the question of what witnesses to put in and what charges to present is based on a review of everything you have. A judge is going to be sitting in the grand jury making rulings and deciding what witnesses should or shouldn't be called based on what they're hearing. The judge is not going to know what other witnesses are out there that the district attorney knows because he's got everything in front of him. It's just not a way to
So there's not a
address the
witness
problem.
list,
no,
like you'd have in-
no. I mean, the district attorney is charged with the duty of investigating the entire case and then culling from that investigation what charges should be submitted, what charges shouldn't be submitted, and what witnesses should be called. I like a judge charging the grand jury. I like a judge sitting
Depends
there.
where. I'd say there's more of a legacy of judicial corruption in Brooklyn. I prefer Thompson, to tell you the honest truth. He's more upstanding and more reputable. If you follow this logic to its inevitable conclusion, this is how you have the great over-federalization of things, because he's espousing a presumption that the DAs are not going to do their jobs because it
The
involves
only
a police
thing I'll
officer.
say, though,
There's
is
no
this.
basis for that.
If you had a judge in the Ferguson grand jury, you're not going to have a DA put up a witness who perjured herself. That's not going to happen. That judge also, like they will do in our trials in the court, they can ask a question, so they can follow up. And we all know that when you get grand jury minutes, lots of times the grand jurors ask lots of other questions, and the assistant district attorney says, "Oh, don't worry about that. That's for another time." Well, no, maybe it shouldn't have been for another time. It should have been right there when they had a question.
But we're talking about all cases, and I like that idea for all
For all
cases.
cases is a different story. This is just one particular political
I gotta
ploy.
jump. That's only our first subject. We're gonna have a bunch of good ones coming up, including right after the break. President Obama's executive actions when it came to immigration, well, they've come to a screeching halt. That after a Texas judge hit the brakes temporarily, at least, blocking the measure. The administration says it will appeal the decision, but how will an appeal hold up when it comes to court? Our legal panel is going to weigh in on that and more after this.